And that just, obviously that wasn't good for the kids. So,
Okay. Now, we have filed proposed disposition of issues, and let me try to pull those up real quick. Now, of course, I'm struggling a little bit, so excuse me. Your Honor, I may need help pulling it out of the box. I was going to pull the proposed disposition of issues in the property division spreadsheet, and I'm not seeing my...
Okay. On the bottom of your screen, there's a button, a green button for share.
Yeah, I've got that, but for some reason I'm not able to click on what I'm wanting to do right now. Let's see. I had it going earlier. Sorry.
That's okay.
There we go. Ms. McBride, would you briefly describe what's been marked as Exhibit P002?
Okay, we're not seeing it on the screen.
No.
We're seeing an email. So if you have 2 screens or 3 screens at your office set up, you're going to need to select the right one when you're...
I'm on my laptop, and that's all I have, and it shows up on my screen. I'm sorry. I'm not even sure what else to hit now.
The hearing began with technical difficulties as attorneys struggled to share evidence on screen, briefly delaying proceedings while the judge patiently guided everyone through the virtual courtroom.
It says you're screen sharing, stop share, start again.
Okay, we see it now. Go ahead.
Okay, good. Ms. McBride, briefly describe what's been marked as P002 exhibit.
this is like the orders.
This is the proposed disposition of issues for our final orders, is that correct?
Yes.
And this was prepared by us with your help, and do you believe it to be true and correct?
Yes.
And are we asking to for the court to award you for instance, we've asked you to be appointed as sole managing conservator. Do you understand that?
Yes.
And Your Honor, I'd like to offer Exhibit 2, my first exhibit, Exhibit 2.
2's admitted.
And then Miss McBride, if I can do this one now. Stop sharing. I'm sorry, Your Honor. I have a spreadsheet that is part of our pre-trials that's in the box that I don't seem to be able to upload right now. I don't know if the court can take judicial notice of what's in the box, and I can introduce it from that.
Why don't you just offer it? I have access to it, but you can just offer it.
Miss McBride, as we had talked and reviewed earlier, our I believe it's exhibit number 3 is our proposed division spreadsheet. Do you recall that?
Yes.
And would you like that to be offered into exhibit as Exhibit 3 offered into evidence?
Yes.
And do you believe it to be true and correct to the best of your ability?
Yes.
And this is where we're awarding the assets and debts as you currently have them. Is that correct?
Yes.
You have a house, but the house is not worth near as much as it used to due to market forces and to severe disrepair. Is that correct?
Right.
And you have not had the money nor the help from your husband to help fix it?
Right.
Do you believe it would be in the best interest for the children to remain in this house?
Yes.
And we do have a equalization that you'd be paying your husband. Is that correct?
Yes.
Once the documents appeared, the court reviewed the proposed final orders, confirming they accurately reflected the agreements prepared with Ms. McBride before admitting them into evidence.
And the rest of the division is just some bank accounts that you have and some separate property that you brought into the marriage that's reflected on this spreadsheet. Is that correct?
Yes.
And do you believe it would be this division is fair and just?
Yes.
Your Honor, I think that's all I have, unless you have any other specific questions. I think it's the proposed order that we have is outlines it traces most of what Judge Mendoza Matthews Rodriguez did, and I would like to urge the court to grant this. It gives all the rights and duties under 153, 132 that Judge Matthews Rodriguez had also ordered. And it's just, we just basically took that order and made it into more of a final order. And I think that we urge the court to grant the divorce and sign this order.
Okay, and just for the record, that last exhibit was P3?
P3.
Okay, that is admitted. And is there a request for a name change?
There is not a request for a name change, Your Honor.
Okay. Okay. And
we have an order that's in the box that, again, we're open if you have any issues with it, but we tried to track what Matthews Rodriguez did and put everything that's normally included into our order.
okay. And just maybe if you would just review the child support provisions with me.
Yes, Your Honor. Again, the only we do not have any specific information regarding his employment right now. We do know that he's doing odd jobs and working. We don't know anything else. Based on that information, the previous child support was set at $445. Again, he's not paid it, and he's not reimbursed any money, so I don't know that it's going to be a real number anytime soon anyway. Ms. McBride is definitely struggling. It's been a very big hardship. I'm not asking for attorney's fees because they would never be paid, of course. But I believe that the minor amount that we have in there is the best that we could come up with a guess based on what his current lifestyle is. He's driving a car. He's getting around, he's doing things, he's meeting people. We think he's just doing odd jobs, but we don't have an actual place of employment.
Okay.
And I can ask that again from Ms. McBride to confirm that.
Attention shifted to the marital property division, where testimony described a deteriorating family home, financial hardship, and proposed settlement believed to fairly protect both parties' interests.
That's fine. You can go ahead and get that confirmation.
Ms. McBride, is the best of your understanding, you do not know where he's employed.
That's correct.
And you don't even know that he has a job that you believe he's working based on what he's doing with spending money and getting around town?
Correct.
Okay. Nothing further, Your Honor.
Okay. Okay, just give me a moment. I'm trying to locate the final decree that was sent in. Okay, here it is.
I think it's P6.
Okay.
And just to confirm, Ms. McBride, you are not asking for a name change, is that correct?
That's correct.
Okay. All right. I will grant the divorce on the grounds of insupportability, and I will enter the decree consistent with what we have discussed here in the virtual courtroom this morning. Ms. McBride will be named as the sole managing conservator of the child, and possession and access will be limited as set out in the proposed disposition of the issues, along with the proposed injunctions, and will find that the proposed property division is a just and right division of the community estate. I will enter the decree. And do we have the BVS form?
I believe it was either uploaded or it was filed, but we do have a BVS form.
Okay. If you could email that to Ms. Seeger, that would be helpful. She does not have it, and box is really for the court reporter. So if you wouldn't mind sending that to her, we'll get it taken care of.
Absolutely, Your Honor.
All right. Seeing nothing else, y'all are excused from the virtual courtroom, and have a great day.
Counsel urged the court to approve the divorce decree, explaining it closely followed earlier judicial rulings while preserving parental rights, responsibilities, and an equitable property distribution.
Best of luck to you, Ms. McBride.
Thank you, Judge.
All right. Take care. All right. Next, we're going to move to our other short, uncontested hearing. on Grizzle or Grizel, I'm not sure.
Yes, Grizzle, and there they are.
Okay. All right, let me go ahead and call the case. We're here on FM 24-009047, Grizzle versus Seals and Teton. Mr. Campos, you may proceed.
Yes, ma'am. Your Honor, I'll just give you a rundown of this case. Has been on file for a couple of years due to a number of factors why it's just now getting to that point of getting concluded and getting the guardian ad litem's off dissolved. But they will be involved here very soon and submit the order. But in the meantime, the Grizzles need some orders, temporary orders, to be able to register for the child who turned 14 today. So, and the Grizzles have raised her basically for most of her life, or at least cared for her before they finally 10 years ago got possession of the child. So it's been at the end of this month, it will be exactly 10 years that they have had full-time possession of this child. And so why we're asking for these temporary orders for today. And as I mentioned earlier, both the
discussion then focused on child support, revealing the father's uncertain employment, unpaid obligations, and the mother's ongoing financial struggles while raising the children without meaningful assistance.
Biological parents have signed an affidavit. Well, in the case of the mom, she signed an affidavit for voluntary relinquishment of parental rights, and the father signed an affidavit of waiver of interest. And in there, they both designated the Grizzles to serve as managing conservators and to adopt this child, Marley. And in their respective affidavits, they waived the right to be served and the right to appear for or be notified of any hearings. And those have been e-filed, and I did upload them to Box, but because they're e-filed, and I can certainly ask the court to take judicial notice of those, and don't know that the court needs to have those submitted as evidence for this hearing. The petition has a temporary request for temporary orders, and in our draft of the order for the temporary orders for today, I provided the quotes from the affidavits to take notice of that those that's the language from the respective affidavits of the biological parents, and why it's not necessary for them to have notice of today's hearing. And so we are asking simply that the court appoint the Grizzles as managing conservator of this child, May Teton, and that we've just listed all the rights so that they can have the right to make medical consents and to.
The judge officially granted the divorce, appointed Ms. McBride sole managing conservator, approved the proposed property division, and concluded the family's long-running legal dispute before calling the next case.
Enroll the child in school, etc. And so all the Grizzles as witnesses, but because it's uncontested, I don't know how much you want to hear in terms of evidence from them. I can give some basic evidence for them so that the court knows that they have had the child for more than 10 years, and have cared for the child because they cared for her before she was left in their possession for the purposes of adoption.
Mr. Campos, I'm having a hard time with your audio. You seem to be cutting out constantly. Is anyone else hearing that too?
Yeah, we agree.
Okay. Yeah, Mr. Campos, I don't know if you want to exit the Zoom and try and rejoin, or if you have a different device.
Let me try that with a different device, and I'll see if that makes a difference.
Yeah, it's very hard for my court reporter to. She and I are both struggling.
I apologize. Okay, I'm connected through my phone.
Okay, we're admitting that device. Yes. Okay, let's see if that works. You'll need to unmute the iPhone if you want to try and use that for audio. It seems to be. Okay. How about this?
That's going to work for me if that works for you.
That is much better. You can just disconnect from the other device if you want.
Well, why don't we do this? Why don't I stop the video?
Okay, that would be helpful.
And then you can hear me and look at me more professionally than in this office here.
Okay. Who do you want to
A new uncontested hearing involved the Grizzle family, seeking temporary conservatorship after caring for a 14-year-old child for nearly a decade with both biological parents' consent.
testify first? I guess I can swear them both in, and then we can proceed that way.
And I'll have, that's fine, and I'll have Rayanne Grizzle testify first.
Okay, folks, if you would just both raise your right hand for me. Do swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes. Yes, we do.
Okay. Go ahead, Mr. Campos.
Ms. Grizzle, let me go ahead and start with you. Is it correct that that Tricia, the mother of the child, Tricia Leanne Teaton, that she placed the child, Marley Mae Teaton, in your possession approximately 10 years ago for the purpose of you all adopting Marley?
Yes.
All right. And today she is turning 14 years of age. Is that right?
Yes.
And prior to 10 years ago, when you started having full-time possession of Marley, did you help care for her during the 4 years prior to her being placed with you permanently?
Yes.
And is it correct that Marley also, that you contacted, and we contacted the person identified as the father of the child, Christopher Lee Seals? Did we do that?
Yes.
And is it correct that both Miss Teaton and Mr. Seals signed affidavits relinquishing?
Proceedings were interrupted when severe audio problems made testimony nearly impossible, forcing the attorney to reconnect using another device before the hearing could continue effectively.
Their interest or their rights to the child, and that they waived any notice of any hearings in those affidavits?
Yes.
Okay. And is it correct that you are seeking the temporary orders today so that you can would be able to enroll the child, Marley, in school, and to be able to deal with medical issues that may come up without any complications, because you only have the affidavit of relinquishment until now? Is that why you're asking the court for temporary orders?
Yes.
Okay. And is it correct that, how long have you and Mr. Grizzle been married?
31 years.
And how many children do you have other than
Marley. Four,
Marley?
5, including Marley.
Okay. And do you believe that it is in the best interest of Marley that you and your husband be appointed temporary managing conservators until you are able to complete the adoption later hopefully this summer, but perhaps it may be into the fall?
Yes.
Okay. And I think that's all I have for you, Mr. Grizzle. You've heard the testimony of your wife. Do you agree that all of that is true and accurate?
Yes.
Under oath, Mrs. Grizzle explained the child had lived with her family for 10 years, while both biological parents voluntarily relinquished their parental rights through affidavits.
Yes, I do.
All right. And do you also agree that it would be in Marley's best interest that you and your wife, who've been taking care of her for more than 10 years now, and that she's lived in your home now for the last 10 years, do you agree that that's in the best interest that you be appointed temporary managing conservators over her?
Yes, I do.
All right. Your Honor, I think I passed the witness. If the court has any questions for them directly or...
Okay. So Marley's going to be in middle school, I take it?
Starting high school, 9th grade.
Starting 9th grade. Okay, great. And how's school going for her?
We got her out of middle school. That's the most important. Hooray for us as a family here.
Yes, those are difficult years. All right. I don't have any other questions for you. Thank you for your appearance here this morning in the virtual courtroom. Mr. Campos, I don't have any questions for you. Let me just pull...
temporary order is submitted. I understand that Ms. Seeger forwarded that to you, so you have that.
Yeah.
I also uploaded it to Box, but I understand that that's, from what you just indicated, that's more for the court reporter. I don't know if you need...
Yeah, we don't need to enter it as an exhibit.
Right.
Just need to review it. And... Sorry, I have my many...
The Grizzles testified that temporary legal authority was necessary to make medical decisions, enroll the teenager in school, and complete the planned adoption later that year.
Screen, so just give me a moment here. Yes, I'm looking at the final version, which is noted as, quote, corrected.
That's correct.
I think we had an edited version. Okay. I don't have any questions for you, Mr. Campos. The court is going to enter the temporary orders, and you can go from there as far as setting the adoption for a final hearing, but the temporary orders will be entered and sent to the district clerk's office.
Thank you very much, Judge.
Okay. Any questions for me?
No, Your Honor.
Okay. All right. Best of luck with the finalization of the adoption. And with high school, y'all are excused from the virtual courtroom.
Thank you.
Your Honor.
Satisfied with the evidence, the judge approved the temporary conservatorship, wished the family success with the upcoming adoption, and closed the hearing on an encouraging note.